My name is Ginger Lerner Wren, and I am a county court judge from Broward County, Florida, which is where Fort Lauderdale is. And I have two courts. One is a regular criminal division, and one is a specialized problem-solving therapeutic court, which is really a human rights effort dedicated to individuals who are arrested with mental illnesses. And this court started in June, almost 12 years. And the Broward court really started out of significant desperation. We, like any other community, jurisdiction in the country, were seeing countless individuals with mental illnesses behind bars, their family members suffering. And in our community, we developed a consciousness that we were going to try something. And we really didn't know what that something was going to look like. The mental health court started out of a ad hoc mental health criminal justice task force that had met essentially for years. There were some precipitating factors in our community, like many others. We had a terrible jail overpopulation. We had individuals dying in the jails with mental illnesses. Our community-based mental health system was non-existent. And we finally had a activist public defender who started really getting it, that the majority of his clientele, or a good portion of the individuals that they were representing, they were just enabling them, going in and out of jail, to the streets, to shelters, to hospitals, back in the jails, and that essentially it was endless. And there was almost this confluence of consciousness back in, I think it was 1996. And I was not a judge. I was coming out of a protection and advocacy agency, a federal watchdog organization here in the state of Florida. I had been overseeing a federal class action consent decree regarding one of our state psychiatric hospitals in South Florida. Very unusual consent decree that wasn't really designed to improve the conditions of the institution, but designed to follow individuals upon their discharge from the hospital into the community to try to identify major gaps in the community-based system of care. Very unusual, very controversial, actually. I knew nothing about mental illness when I was asked to come into this role. I had been the public guardian for Broward County, which meant that I was in charge of making health decisions, financial, taking care of individuals' finances, making sure that they had homes, places to live, etc., for those who couldn't care for themselves. And these were all adults, and we were very fortunate to have this kind of a program in my county. And that was pretty much a very general kind of background that I had. So the position that I took for the Advocacy Center was very highly specialized, and it was a pretty large, wonderful learning curve. So when I ran for office, the federal class action was pretty much winding down. Oftentimes monitors or change agents create a lot of hostility, bringing about the social reform, and they only last so long, and that role was pretty much winding down, and I had always, since I was a little girl, wanted to run for office. I wasn't sure which office, but over time, almost through a process of elimination, I came to think that the judiciary was really a really wonderful fit. So when I was running for judge, this task force was ironically, and there's a lot of irony, a lot of serendipity to all of this historically for us. The task force had decided finally, they didn't know what to do, but it was really Howard Finkelstein, Chief Public Defender at the time in Broward County, who finally, after years of meeting and talking, said we want our own court. And the idea, the concept, we really didn't think much about it at the time. We had no political will for a CIT program or any other kind of diversionary measure. We had no money. To this day, we still don't get any money. The CIT program or the crisis and training types of teams, police teams that intercept and divert by law enforcement, trying to prevent people from entering the jail system. We really thought, at least I thought, that this effort was going to be largely symbolic in the beginning. That my plan was to hold court during lunch hours every day. And we borrowed some staff from local mental health centers. And I had just applied the same kind of skill set that I had learned when I was doing my work in this federal class action. And I did, thank goodness, become highly skilled and knowledgeable in the area of psychiatric rehabilitation and systems and recovery, etc. And so we started, and we had no idea, not a clue. We called it, or at least I called it, a court of conscience in the beginning. It was going to be a gift to the NAMI, local family members, so that at the very least they would know that somebody in authority got it, that there might not be money for direct service, might not be able to transform community-based healthcare systems, but the message would be that from here on out, somebody in the area of criminal justice would stand up and simply say, it's enough, it's enough. We're not going to do business like this anymore, that the criminalization of the mentally ill is an absolute horror, that it is unjust, that it is inhumane, that we're not accepting it in this county. And it really, the shared vision, and I look back on it, the shared vision, the message, the commitment that this community had to the notion that, possibly we could stand up without anybody giving us permission, not from the governor, not from the legislature, not from Congress, that we can do it on our own, was extremely empowering to this day.